Hi all, Frank, aka Bootmakers here, and I did not expect to have these two boots sitting in front of you again so soon. But here we are, as the gloves appear to have come off and things are getting ugly between Oak Street and Viberg. There's been a material escalation in the dispute between the two companies, as it appears that Oak Street has retaliated against Viberg by administratively suing to void or cancel Viberg's service boot pattern. Now, I'm speculating as to whether this was in fact retaliation, but I'll get into why I think it's so shortly. As I suggested in the last video, I am not on the inside of this thing and cannot possibly have all of the details. I'm merely looking at any facts that I'm aware of to give my opinion in a cursory and speculative analysis. Before watching this video, I would recommend watching my video linked above and in the description entitled Oak Street versus FTC versus Viberg in order to get some context about what has been happening between these two companies and to help explain the developments I'm about to discuss here. So, let's get into it. The dispute between Oak Street and Viberg has materially escalated, and there is a possibility that Viberg could lose the patent it has on its service boot. Before we get started, a quick disclaimer. Nothing stated in this video constitutes legal advice, and thus it should not in any way be taken as such. Any entity that comes across this video should not assess its legal and/or statutory compliance, requirements, legal strategies, or other legal processes concerning any law, case, or regulation based upon this video. Instead, it is my strong recommendation that said entity contact an attorney who can provide advice in addressing its legal issue or responsibilities. Okay, I'm going to try to keep this organized. I'll start with a brief timeline of the events that I'm aware of. Next, we'll touch upon patents generally, just to show what Viberg likely had to do to get its patent in the first place. Next, we'll get into Oak Street's lawsuit, that is, the legal complaint against Viberg, to see what Oak Street is arguing. Lastly, we'll superficially touch upon what OSB has to show in order to have Viberg's patent canceled, and what Viberg might have to do to defend the suit. Let's begin. The relevant timeline starts in 2020. That's when Viberg was granted a patent on a pair of, quote, boots. That patent granted Viberg ownership of several aspects of their boots, including, but not limited to, a distinctive stitch-down construction, a unique 3-row stitch pattern on the seam that connects the quarters side panel with the vamp, forefoot, an intentionally low flattened profile in the toe box, an intentionally low profile with the overall height of the boot being only 4.75 inches, and a shorter heel. I didn't find any evidence of prior challenges to Viberg's patent leading up to this OSB dispute. OSB dropped its new storm boot around the second quarter of this year, 2025. According to OSB's complaint, Viberg forwarded a cease and desist letter to OSB in May. In July, the Federal Trade Commission sent a compliance warning to OSB concerning its Made in America designations. In early August, Viberg and OSB ostensibly traded jabs on social media, though neither party actually named the other. One of the more interesting parts about OSB's social media posts was their ominous claim that more facts would come out later. And lastly, in what appears to be a retaliatory act against Viberg, on August 6th, OSB filed a petition with the U.S. Patent Office to cancel Viberg's boots patent, triggering the process of an administrative trial with the USPTO. I have just a couple of thoughts on this timeline. The timing is a little challenging to nail down with respect to Viberg. They sent the cease and desist letter in late May, and then only a month later, the FTC comes knocking on OSB's door. That followed by roughing up OSB on social media. Assuming OSB's suit was retaliatory, it could have been for any of these reasons. But I can understand why Viberg would go after OSB. Viberg's patent is still live as of the date of this video, and I don't know that OSB was within its right to make a boot that looks so strikingly similar to a Viberg. My sense is that the storm boot could have waited out OSB's challenge to the patent had they chosen to go that route in the first instance. So, it's probably best to start with discussing what Viberg likely had to do in order to procure its U.S. patent in the first instance. I don't know much about patents or patent law, but the little I have gathered has shown me how complicated a process it is. I guess there's a reason patent lawyers have to take an entirely separate bar exam, colloquially referred to as the patent bar. That is to say, take what I say with a grain of salt. Title 35 of the U.S. Code covers patents. Generally, 35 U.S.C. Section 101, 102, 103, and 112 of the Code govern when a patent may be sought. Under Section 101, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. Under a portion of Section 102, a patent may not be issued if, quote, the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention, close quote. In other words, the product must be novel. Under Section 103, a patent may not be issued, quote, if the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains, close quote. That seems to mean a patent cannot be granted where an invention would most certainly have come about under any average inventor within the field that the invention is relevant to. And under a portion of Section 112, there must be a, quote, written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms, close quote. Assuming those requirements were met, Viberg would have to have prepared a complete patent application, including drawings of the product, and submit these materials to the United States Patent and Trademark Office, or USPTO. The USPTO reviews and renders a decision at some point. Viberg seemingly met the statutory requirements and was thus issued its patent. It seems the process can take years, as I believe Viberg applied for its patent in 2017, and it was not issued until 2020. So, we have an idea of what Viberg had to do to get its patent. What does OSB have to do to challenge it? Well, let's start with a threshold idea. Even where a patent has been evaluated and issued to an inventor, it's important to understand that said patent is only, quote, presumed valid, close quote. That presumption is rebuttable when certain conditions are met. But that burden rests on the challenger to establish the invalidity of the patent. With that in mind, and strictly within the context of what is available within the USPTO itself, I am aware of 3 mechanisms available to challenge a patent, though there may be other nuanced ones. First, the challenger might consider what is called post-grant review, or PGR. What a PGR basically permits is for a challenger to demonstrate how a patent statutorily fails in an adverse setting, aka court-like. For example, say an invention was not novel because someone else had created something that was substantially the same a year prior. That patent would likely fail 35 U.S.C. Section 102. That should mean that the patent should not have been issued and the challenger would win, right? Perhaps. But the issue here is that OSB is time barred since a PGR must be pursued within 9 months of the patent's issuance. Second, any party, including the challenger, can request what is called ex parte reexamination. This kind of challenge, however, is not adversarial and is thus more informal as compared to PGR and the third mechanism that we'll discuss shortly. In ex parte examinations, any third party can simply submit information to the USPTO which raises, quote, a substantial new question of patentability, close quote. If the party does so, the USPTO can re-examine a patent for prospective cancellation, but the statute certainly suggests that they do not have to. Third, a challenger can pursue what is called inter partes review, or IPR. This mechanism is somewhat similar to PGR in that it permits statutory challenges to a patent in an adversarial setting. IPR is different from PGR in 2 ways that I want to highlight. First, IPR is not limited to the 9-month window, unlike PGR. That's good for OSB since they are time barred from using PGR. However, and this is the second difference, IPR places a significantly heavier burden on the challenger. Unlike PGR, in IPR, the challenger must demonstrate, quote, a reasonable likelihood, close quote, that the challenger, quote, will prevail, close quote, before they can even file the IPR. Well, as you will see shortly, OSB's complaint against Viberg is adversarial. Thus, it appears that OSB's challenge is of the IPR type. So what is OSB arguing here? Let's open up the complaint and find out. So OSB starts out by stating it has been and will continue to be damaged by the continued registration. So I don't think that this statement is part of OSB's actual argument. Rather, that line probably goes more to showing that they have standing to file this petition, since one of the things that they'll have to demonstrate at trial is the likelihood of damage if the patent is not canceled. OSB next lays out the patent as described as Viberg, noting that Viberg described the product as, quote, boots. They next provide that both they and Viberg manufacture boots as competitors. The next couple things are what will be most key in terms of the suit. First, you'll see here that OSB in sum and substance admits to their boot having similarities to Viberg's boot. That is, OSB does not contest Viberg's claims that OSB's, quote, service-style boots feature similar design elements, close quote, as compared to Viberg's patent. Rather, and this is the second key thing I'll note, OSB appears to be standing on business. They attempt to shut down any notion that they copied Viberg's boot by arguing that the patented design is, quote, not unique to Viberg, close quote, adding that the claimed features are, quote, industry standard features, close quote, that are commonly used by other footwear makers. Most importantly, the third key thing OSB argues is that the widespread use of the elements makes them, quote, functional, close quote, and thus incapable of being utilized for trademark purposes. The importance of the word functional will become a bit clearer shortly. So, OSB has sort of laid down a foundation for the basis of its argument. Okay then, what does it all mean? I think it might be helpful to look at it from the perspective of each party. For OSB, what do they have to prove to the administrative judge who will presumably hear the matter? Well, here, they are the proponent of the action, and they are claiming patent invalidity due to functionality. So at bar, the burden is not on Viberg to show that OSB is wrong. Rather, as I suggested earlier, the burden rests on OSB to prove their functionality theory. All right, what the heck is functionality? In the context of patents, in what many courts call a, quote, stringent test, functionality seems to mean that, quote, the appearance of a claimed design is dictated by the use or purpose of the article, close quote. In other words, if the patent design is essential to the use of the article, the USPTO cannot grant a patent. When the USPTO does unknowingly issue such a function-based patent, a prospective challenge could see the patent ultimately voided. The basis of that rule is about preventing unfair competition by preventing competitors from usurping useful features for themselves. Okay, how about Viberg? Well, they don't hold the primary burden here, but they have to defend the action. Basically, they'll likely have to counteract OSB's argument. One way they might do that is to show that the features they claim in the patent are not functional, or at least not purely functional. One of the chief ways to do that is to try to show that the patented feature is, quote, ornamental, close quote, in design. What the heck does ornamental mean? Basically, it's anything about the claimed design that is not functional. I'll try an example. And I do mean example because I am not a court and cannot say for sure what is ornamental versus what is functional. OSB's boot doesn't really have this feature, so I think it's a non-issue in this case. But look at this tight stitching on the Viberg boot. See that there? The very tight SPI? It surely serves a function in attaching the upper to the lower. But that particularly tight stitching is likely not essential to the functioning of the boot. Why? Well, OSBs and other stitch down boots that I own don't feature Viberg's tight stitching. Look at the OSB boot. Doesn't look quite the same, and the SPI is not the same in my opinion. Yet the uppers of the OSBs and my other stitch down boots remain solidly attached to the lowers in essentially the same way as the Vibergs. Going back to our case, the courts make clear that, quote, a design patent only protects the novel, ornamental features of the patented design, close quote. So depending on how a court assesses a product in the context of that rule, Viberg could feasibly maintain a claim that their tight stitching is ornamental and not functional in design. Unfortunately, it's frequently the case that the patented design has both functional and ornamental features. What might be tough for both Viberg and OSB is that the functional-ornamental dichotomy is not always a bright line in a legal proceeding, and you just don't know how it's going to go. I'll be paying attention to this one. There's already a trial schedule up. Notably, Viberg has to respond within 40 days of OSB's complaint, which was filed on August 6th. There will be discovery and other quasi-pretrial steps to go through. And the estimated trial date, as of now, is slated for as early as 2026. I'll try to keep you all informed on the suit's progress. The outcome could have significant reverberations in the heritage boot space. Chiefly, if Oak Street's suit is successful, they are not only doing themselves a favor, but likely every other boot manufacturer that sells products in the States. Time will tell. Well, that's all I got. Take care.